Okay, well, we may be expecting a few more people to join us over the next few minutes, but I'd like to extend a very warm welcome to everyone to this second webinar to reflect on the parole system and what needs to be reformed. My name is Loraine Gelsthorpe and I have the pleasure of chairing this evening's webinar. I am Director of the Institute of Criminology, Professor of Criminology and Criminal Justice, with research interests in decision-making in the criminal justice system, and more broadly, the links between criminal justice and social justice. Well, for those of you who were present yesterday or who've managed to watch the webinar from yesterday, the questions raised revolved around the meaning of a root and branch review of the parole system. Also, there were questions as to whether or not a review of the parole system itself is sufficient. Individuals may benefit from interventions and programs in prisons as preparation for parole, but arguably this is not sufficient. What is needed is a genuine focus on reintegration. And in this regard, I might add that it's perhaps important to consider how far the Rehabilitation of Offenders Act militates against successful, effective reintegration. In addition, there were some searching questions about the way in which parole decision-making might benefit from more effective data collection and transparency, recognising that the wider education of the public is needed, plus some constraints on populist retributivism via some informative myth-busting, we could argue. There were many other excellent observations and questions in the webinar. Today, in this second webinar, the focus is very much on values, aims, and solutions. We've got 3 topics, 3 speakers under the broad heading of identifying solutions. So 3 speakers and respondents, and there'll be an opportunity to ask questions after each of the speakers. And then at the end, there will be opportunity for some general questions before Harry Anderson offers us some incisive concluding reflections. Without further ado, I would like to introduce the first speaker, Faith Geary, who is Director of Development and Improvement at the Parole Board and has been in that role since 2015. Faith has a background in law with some 15 years of experience working with the civil service, starting out as a caseworker in an employment tribunal. She's also spent a number of years working in the Ministry of Justice with a particular focus on improving IT and technology and providing better information to inform decisions. And if I can introduce a respondent to Simon Crichton, who works for Bat Murphy Solicitors as a consultant, although he was a founding partner at Bat Murphy. He specialises in prison and public law, working particularly with life sentence prisoners, and is perhaps one of the first lawyers to work exclusively in this area. He also has interests in data protection and privacy cases. Timing is going to be tight, so forgive me if I intervene to hurry things along here and there. But please welcome our first speaker, Faith Geary.
Hi, Loraine. Thank you, Loraine, for that very kind introduction. As Loraine said, my name is Faith Geary, and I'm delighted to be able to speak to you all this evening. I'm going to start by saying I'm a practitioner, not an academic, and my presentation over the next 15 minutes will reflect that. I'm just going to share my screen with you all. So I'm actually now the Chief Operating Officer of the Parole Board, and that means I'm responsible for the day-to-day running of the board, making sure that members who make decisions have the backup, information and administrative support to review the ongoing detention of over 17,000 prisoners each year and allow for the safe release of about a quarter of those people back into our community. Many of these people have committed the most serious of offences and can only ever be released if the Parole Board directs it. We heard lots of interesting thoughts yesterday about what the board could do and what its functions could be, but it is important to take a moment to reflect on the most important thing it actually does: protect the British public. I want to share my story of the effectiveness and dedication of the Parole Board in doing just that. When I joined in 2015, there was a huge backlog of cases. I was told we would never get Parole Board members to change the way that they worked, as the parole system had been the same for many, many years. Our annual staff opinion survey scores were low. Most people wanted to leave the organisation within 2 years, and we were constantly recruiting. That was at a time that the board had numerous projects underway to make things better and never completed any of them. Oral hearings took place, the Parole Board rules existed, but no one seemed to take much notice of them. Over the years, the board has changed, and there is clearer direction and visible leadership from Martin Jones as our chief executive. We became a modern, professional organisation that not only wanted to be effective and efficient, but to be fair. Backlogs reduced, and we engaged members and staff in changes affecting them, and embraced modern technology to help us stay on top of our work. Hearings became more effective, and particularly since 2019, the rules have been strengthened, read and applied with better dedicated in-house legal support for the membership. Our staff have stayed and developed within the organisation. More members have joined, progressing to chair oral hearings, and the diversity of our panels has increased. There is a greater sense these days that the Parole Board wants to show itself as independent, that it wants to make fair and balanced decisions, and most importantly, we always ask ourselves the question, how can we improve? Today's a welcome opportunity to take a step back from my day job and reflect on where we go next with your help. Reviews of the Parole Board are not new to me, but a review of the parole system is. In the last 5 years, I've been involved in 5 reviews of how the board works. The Ministry of Justice Root and Branch Review, launched last month, is the first in my time looking at the wider system. We see this as an opportunity to push for changes, not just in the way we work, but the wider prison and probation system too. The Root and Branch Review allows us to ensure that there is joined up working across stakeholders so that others are as proactive as we have been. There are 5 areas where I believe reform could improve the parole system. Firstly, the Parole Board is a modern court. In recent years, we've undertaken better analysis of our status, powers and constitution, and so we're on a firmer footing. We are now acting much more like the court we are. Last week, the Supreme Court in the case of Gelsthorpe agreed that the Court of Appeal had correctly identified the board as a judicial body. Like tribunals, our members are experts who go through a rigorous selection process and are recruited for their ability to make risk-based decisions on an independent assessment of evidence without fear or favour. We build on that with compulsory training. Further reform should be less about the administrative structure that the board sits within and more about judicial process, with powers akin to those of a court or tribunal to ensure better evidence and the right legal backup and training for members to support their decision-making. Reform should encourage professionalism across the system, including members, report writers, and the standards of those representing at hearing. When the board issues directions for information on a case, compliance can be very poor, and improving this must be a focus for further reform. It is the biggest contributor to just short of 40% of oral hearings having to be adjourned each year, and panels holding on to cases for many months longer than they need to in getting them to a conclusion. We encourage our panel chairs to own cases if they cannot decide them on the day of a hearing and problem solve them, minimising delay. The rest of the system has been slow to catch up, and the management of a parole case for the Secretary of State is split across teams in prison, probation, psychology and the centre. It is difficult to point to one single person with responsibility for a case for the Secretary of State anymore. There are some positive changes ahead that might help, including the rollout of a new offender management model where a panel will get one recommendation rather than two. But is it also time for a radical rethink of the role of the Secretary of State representative? We should continue to focus on increasing the diversity of the membership. This is important given a huge proportion of the prison population is from a minority background. Our investment in technology has paid big dividends and has allowed us to scale to meet increased numbers of cases coming to us each year and develop a range of new and flexible processes that can be adapted to fit different types of cases. In response to COVID, we transformed all oral hearings almost overnight from face-to-face to telephone or video and kept 95% of prisoners' reviews going. Unlike the courts, we do not have a parole backlog and are committed to keeping the best bits of these new ways of working as we continue to transform and get back to some normality over the next year. We remain firm believers, though, that face-to-face oral hearings have huge value, but only where they are needed to ensure fairness. Arguably, in some cases, sending a case for an oral hearing would be unfair. Paper hearings and remote hearings remain relevant as we can conclude more timely reviews of cases, particularly recalls. If someone can be safely released, it is more effective in terms of resettlement and safe management if that can be facilitated sooner and before the prisoner has lost their accommodation and possessions in the community. Technology doesn't stand still. Artificial intelligence, or AI, is having an increased role in how organisations work. Could AI help us to streamline the dossiers of evidence members must consider and save decision makers time wading through lots of duplicate information? This is something we're just starting to explore. Secondly, even greater transparency. To have the confidence in the work of the board, you need to know what we are doing and trust in our ability to make decisions. The board's been opening up since it was created 50 years ago, from a closed system where a member never met or spoke to a prisoner or gave reasons for their decisions, to one where panels meet and question prisoners and professionals routinely at hearing, and will consider the views and impact on victims as part of the process. Following the judgment in the case of McCourt, a precedent has been set that victims have standing to bring a judicial review against a parole board decision, and we wait to see how the court develops this case law. We've taken huge steps in the last 3 years to shine a light on the system. We've issued over 4,000 summaries of our decisions, mainly to victims, and we publish reconsideration decisions on cases online, 175 of these to date. The fact that we can now explain our decision on a case and have a process internally to look at decisions again has helped to rebuild public confidence in our work. And we are starting to see more balanced reporting in cases when a summary is used by the media. Public parole hearings take place in many countries with systems similar to ours, including Canada and New Zealand. We think opening up hearings for victims and the public to attend with the right safeguards in place could increase understanding of our work and give victims an increased sense of control over a difficult and confusing process. The greatest protection for all victims of crime remains the ability of the board to protect the public and not to release people who will go on and commit serious further offences. It is important that transparency does not impede our central decision-making function, and we need to carefully consider the conflicting points of view of prisoners, victims, the media, and the public. We've supported the opening up of hearings in our response to the consultation, but think that changes will need to be carefully paced with pilots. There are other steps we can take that may be quicker to do and just as effective in continuing to increase openness. Building on the publishing of reconsideration decisions, should we now publish the outcomes of case reviews following a serious further offence? Should we name panel members on our decisions? And should we publish summary decisions in certain cases? These steps would make us more court-like and would increase accountability. Some of the best people to speak about parole decision-making are the members who make those decisions. We can use members more to talk to the public through the media about the issues that matter to them, how we make decisions, how sentencing works, what protections can be put in place for a victim when setting licence conditions, what's involved in making a decision for whether a terrorist can be released or an IPP prisoner who is many years over tariff. Transparency has focused in the last 3 years on the rights of victims. It is equally important to ensuring procedural justice for prisoners, some of whom are vulnerable. A member told me of an IPP prisoner who began offending when he was 14 years old because he went to school one day and came home to find that his mother had moved. He lived on the streets after that, lacked trust in people, and so began an escalating pattern of offending. For people like him, the parole process can be confusing, difficult to access, and beset with delay. Good representation from people like Simon is invaluable in helping these people navigate the system. But could further investments in IT in prisons allow someone to track their parole review with the same ease you track an order on Amazon or access your bank information through telephone banking? There is very limited research internationally on the use of video hearings in courts and tribunals, and none in the context of prisons and parole. We welcome further research in this area to help us improve our use of video and telephone hearings and ensure that they are effective and procedurally fair. As a next step, having representatives in the same room as their clients when attending a video hearing, even if the panel are remote, will increase support and is something that we are keen to return to in many more cases once it's safe for us to do that. Thirdly, a radical rethink of recalls across the system. The recent tailored review of the Parole Board commented at length on how poor quality evidence and delay is a whole system problem needing a whole system solution. We believe that the root and branch review should take a radical look at how recall prisoners are managed across the system. In April, we reviewed over 1,000 recall prisoners who were waiting for an oral hearing and have been able to conclude most of those on the papers or by a remote hearing. The system for managing recall is very different in Scotland, where it's the board who recalls prisoners to custody. The caseload in Scotland is much smaller, but could we reduce delays in deciding recall cases by decision makers in the board looking at them much earlier than currently happens and using the resources that goes into these cases across the system in a different way? Fourthly, safe progress for the remaining IPP prisoners. Should there now be a dedicated cohort of members to manage the remaining IPP cases and ensure cases progress between reviews? Panel chairs sometimes use adjournments to do this now, as in the case of a prisoner with significant cognitive difficulties and for whom the only way of managing risk was to make sure he followed clear rules. The panel gave him a clear instruction to stop using drugs in prison. They adjourned the case and checked on him over a 6-month period. He did as he was told. His longest period of abstinence before this was about a week. They released him last week to a specialist accommodation provider. He was 8 years over tariff. In our experience, there is more likely prospect of effective progression if prisoners are alive to the reality of needing to work on risk rather than being given an unrealistic hope. Wouldn't it be fairer for prisoners to see a light at the end of the tunnel and know that someone, independent of the prison or probation, is keeping an eye of their progress and properly empowered to do that? And finally, risk assessment in terrorist cases. There are dangers in releasing potentially dangerous people without a risk assessment. Since our remit for terrorist cases increased through the Torera legislation in February, we've created a dedicated casework team to manage the reviews of all convicted terrorists and those offenders who have not been convicted of a terrorist offence or had any terrorist connection to the conviction, but for whom there is evidence that there may be a terrorist issue. This could relate to a prisoner who has been radicalised or has been associated with other known terrorist act prisoners in custody. Given the issues of radicalisation that these cases present, the board's management committee has taken the view that they should be managed and heard by a dedicated cohort of members recruited specifically for their skills and experience to sit on these cases. They've received specialist training and undertaken security clearance to allow them, in turn, to consider the most sensitive of information. The parole process takes time. Panels take empirical decisions based on information and evidence. More time is required if sensitive information is involved, requiring non-disclosure. We need to reform the way that agencies work together to ensure that those making the decisions understand the full picture on the threats someone could present in these types of cases. Thank you for listening, and I'm going to hand over to Simon to respond.
Thank you very much, Faith, for a very effective summary of what's been achieved and what else needs to be reformed. And yes, indeed, Simon is now going to respond. But can I just interlude with intervene and encourage people to put questions and comments in the Q&A tab at the bottom of the screen. Please put questions there rather than in the chat, and there'll be opportunity for us to address those questions later. But over to Simon. Thank you.
Thank you very much, Loraine, and thank you, Faith. I'd just like to start. I'm really sorry. Can everyone hear me okay? Yeah. Faith started off by saying that the function of the Parole Board was to protect the British public. And I'd just like to start by trying to centre us back into not losing sight of what rights are actually at stake in a Parole Board review. And the Parole Board in its current form exists to vindicate the Article 5 and common law rights of prisoners. And it's their rights that are at stake. If it wasn't for those rights that were at stake, the Parole Board would still be the strange secret advisory body that Nicky Padfield outlined to us. Now, in vindicating those rights, it's necessary for the Parole Board to balance and take into account other competing interests. But the function of the board is to decide on this most fundamental right, the right to liberty. And it's no less important because it becomes at the end of a sentence of lawful imprisonment than any other decision that affects people's liberty. And I would just say that I think it's really important to keep that in focus, as the process has to properly respect those rights. And I'd also just like to say that I think the increased focus on equality that we've been hearing in the presentations yesterday and today is welcome, and it's essential given what we know about the systemic problems with the criminal justice system in that regard. Moving on to the sort of the practical position we're in at the moment, I'd just like to go back to the case of War Boys, which I think is, since Nicky mentioned it right at the start yesterday, it's been a little bit of the elephant in the room. And why is it so important? And I think it's really important because it creates an impetus for change for everybody involved in the parole process. And I'd suggest it's actually, although it seems to have brought about a slight crisis of confidence in the Parole Board, I would suggest that it's actually a huge opportunity for the Parole Board to properly reconsider how it performs its functions. Now, the immediate response we've had to War Boys has been entirely focused on public accountability, victims' rights. We've had the summaries, the reconsideration mechanism. We've now got a consultation about public hearings. But what we haven't heard from War Boys is what the practical implications have been for Parole Board members and for prisoners and for their lawyers. And I think the problem it's created is that the Parole Board can never do enough. It's increasingly being used as a repository for failings elsewhere in the criminal justice system. And what is happening is the problem else you can do, there's always something else you can look into. But I think the Parole Board's begun to realise that it can't actually perform that task or that function in its current form. And that's why I say it's an opportunity. So, for example, if the police decide not to prosecute somebody, the solution now is just to tell the Parole Board it's their problem and they've got to investigate it. But how can the Parole Board carry out that inquiry when it can't even enforce a direction for the police to file a report that they need to carry it out? And so I'd suggest that there's a problem being forced onto the Parole Board, and it's making Parole Board members' lives probably as intolerable as prisoners' lives are. And the second practical problem that's creating is one of non-disclosure. There's been a lot of talk about transparency and openness, but we have to remember that it's transparency and openness for prisoners as well as for people outside the parole process. And in terms of dealing with new allegations, this is a problem at its most extreme. And if it's not handled carefully, I think it will allow the prosecuting authorities to effectively try and start imprisoning people without due process. I'd just like to touch on the reconsideration mechanism. At the risk of disagreeing with Peter's comments about this yesterday, I would suggest that it's actually been quite an ill thought out response to a problem that doesn't exist. And the reason I would suggest that is that it shows a complete lack of confidence by the Parole Board in its own processes and its own standing. So if the Parole Board is a court, as we heard from Gourlay, this is something that's gone back years and years, if the Parole Board is a court, its decisions are its decisions. Other detaining authorities don't wait for an appeal before their decisions are final. Mental health review tribunals, immigration tribunals, they release people. And I think that's the Parole Board's job, and it has to have complete confidence in its ability to do that. And introducing some sort of, we might have got it wrong, please challenge us, or please, we won't implement our decisions unless you've had a chance to challenge it, I think shows a lack of confidence in the Parole Board and its own abilities. On the issue of public hearings, I think that it is important to remember that the consistent law of the country has been that Article 6 is not engaged in a parole review. So there's no assumption of an open public hearing. What is engaged are the Article 5 and 8 rights of the prisoner. And I would suggest that the only proper way to proceed is for public hearings to be considered on a discretionary basis where the prisoner makes that request. And to suggest that it falls within the discretion of other parties to make that request is wrong and is contrary to what we know about the protection of Article 5 rights. In relation to, Faith touched on the increasing sort of expertise in terrorism cases. I think that it's probably just worth referring back to the discussion that took place between Joe Bailey and Fergus McNeill yesterday, which was really instructive. And this danger that there is some sort of quasi-scientific risk analysis that can determine everything for everybody. Even after the SOTP debacle, and for those of us with long enough memories will remember 20 plus years ago when armed robbers were told that they couldn't do thinking skills programs because it made them better armed robbers. There is no scientific basis for these courses, and what they have to do in the current pandemic, particularly, we've all come across cases. I'll give you an example of somebody who spent 6 months waiting to do a thinking skills program, doing everything he could in his cell, and yet the probation service and the Parole Board decided because it wasn't an accredited course, he couldn't be released. And that is just not a tenable position for a basis for continued imprisonment. And people really are going to have to think very carefully about that. And then my final thought, because I realise my 5 minutes are up, is what will actually increase public confidence in the Parole Board going forward? We have to grasp the nettle that the core function of the Parole Board is releasing people. And that's never going to be a popular thing to do. And whatever you do, you won't make that popular. And it's a mistake to think that having public hearings will cure that. And we only have to look at the experience of the senior judiciary over their Brexit decisions, which were all held in public, to show that that doesn't make the public like your decision. And I think the important thing is to have an organisation that's purposeful and confident in what it does, but above all, one that's fair, both in its process and its outcomes. And the need for the Parole Board to be defensive and over-explanatory is probably a hangover from the days when it was just an adjunct of the Home Office and the Ministry of Justice. And what the Parole Board needs to do is actually have the confidence in what it's doing and move forward as a core with all the confidence that would give it. Thank you very much.
Thank you very much, Simon, for those acute observations. We have just a few minutes for Q&A at this point, and I'm going to select some of the questions from the Q&A, but some of them I think will be addressed later, and there's an opportunity also to ask them in the general Q&A section. But one of the questions comes from Bradley Reed, and it's, is a move to further transform the parole system into a full-blown court or tribunal going to further embed the competing interests between victims' rights and prisoners' rights and result in just another hurdle for prisoners to jump through? Isn't it the case that the Parole Board is being politicised? So Faith, would you like to lead off on that one? You're on mute, Faith.
Schoolboy error. I should be used to this by now, having done Zoom calls for every online meetings for the last 9 months. Loraine, are you okay? Can you just repeat the question for me? Sorry.
Yes, it has jumped. So this was a question. Sorry, I'm just trying to find it again now. It's to do with the balance of rights. I'm sorry, I'm just trying to find it now.
Oh, I've got it, Loraine. So it's a move to further transform the parole into a full-blown court or tribunal, going to further embed the competing interests between victims' rights and prisoners' rights and result in just another hurdle for prisoners to jump through. I think I go back to what I said in the presentation, that for me, this is not about kind of a structural move really into the courts or tribunals service. It's about the court, it's about the Parole Board having the powers that you would expect of a judicial body, and it's more about judicial process. And I think that would actually only benefit prisoners. So the ability to be able to enforce our own directions better. The impact of that at the minute is felt by prisoners because it delays their reviews. So I think it should benefit prisoners by giving us that power to kind of enforce our directions better.
I just say that I think that it's probably wrong to frame it as two competing rights, that there aren't actually competing rights between the prisoner and the victim. And I say that because the victim doesn't have rights per se in the parole process, and cases like the McCourt case are talking about standing in the judicial review process, which is very different. The victim's rights in the parole process are prescribed by statutes and are about the rights to information. And so I think it would be wrong to see them as competing rights. And in fact, enhancing the prisoner's rights in the process enhances the victim's rights because they know that things are being done properly. And so it's not a competition, but the two actually move together in tandem, I think.
Okay, thank you. I'm going to add another question here from an anonymous attendee. Many probation officers view oral hearings as an adversarial process. Public hearings will do nothing to alleviate this. How can oral hearings be less adversarial? So again, Faith and Simon, if you'd like to address that one.
So I think it's very important that when anybody goes, it's really important at an oral hearing that evidence is tested. And I can understand that can feel difficult where you are there as a professional and you are being asked or questioned on your opinion. But that's really important for a panel to be able to make a balanced decision about the risk that somebody presents. I think what we're committed to in the Parole Board is doing whatever we can to increase understanding about how the parole process works, and we will do that for probation officers too, so they know what to expect when they go to an oral hearing and how that's going to work. And we get quite a lot of probation officers who are new who will come and watch an oral hearing, and we're very open to that so that they can get familiar with it. Simon, is there anything you'd add?
Yeah, I think that probably the more people see of oral hearings, the more they'll realise that in many cases the probation officer's evidence is accepted by all parties, and possibly the panel test it more than the prisoner does. And it would probably increase people's understanding to see that in such a large number of hearings, the prisoner is actually in agreement with the offender manager of the probation service. But I think that, what we can't get away from is there will always be cases where the Article 5 requirement is such that there has to be, as Faith said, Faith is absolutely spot on, there has to be a very anxious scrutiny of that evidence, and that may involve difficult questions. And as professionals, that is something that people will have to prepare for and understand, that their evidence does have implications and consequences and will be tested.
Okay, thank you both. In the interest of time, I'm just going to take one more question now, and then there'll be later opportunity to ask some of the other questions. Again, this is a question from an anonymous attendee who says the possibility of using artificial intelligence to extract information from parole dossiers was mentioned. Could you say a bit more about the evidence base for that suggestion? Are there any analogous settings where AI has been able to carry out the complex synthesizing of information and context that panel members currently do?
Really good question. So I think initially what we're looking at is a parole dossier can go from anywhere to a couple of 100 pages up to over 1,000 pages. And quite often that can include duplicated information. And so if there is any way that we can use technology to help kind of focus that and make it into more of a quality dossier that will support members in their decision making, that's the kind of thing that we're open to exploring. And we've seen it, we know of examples of that where it's being used in other public bodies who have decision-making functions whereby you have to assess a vast amount of evidence and to try and just improve the quality of that. But our initial thoughts are really around how do we reduce some of the duplication that we see quite a lot in dossiers so that members can be have a good quality dossier that supports their decision-making and helps them to kind of ask the right questions and test the evidence properly.
Okay, thank you. Simon, I don't know whether you have anything to add.
I would just say that I think there are tremendous concerns about the use of artificial intelligence, particularly for qualitative decision making. And one of the problems that you have is that what can appear in people's records, which starts up the flags and the warnings for concern, are entered on a subjective basis. And the experience of all analysis of this has shown that it can exacerbate problems of racism and discrimination because of who's being reported in the first place. And so then how that flags up concerns. So I think that I would urge the most extreme caution for the rollout of any artificial intelligence, because it could just end up making things far worse than they currently are.
Okay, thank you. At this point, I'm going to suggest that we move on to the second section of this evening's webinar, with huge thanks to both Faith and Simon for raising the questions that they've raised and outlining some possibilities, but also some pitfalls at the same time. So our next speaker is Professor David Feldman, Emeritus Rouse Ball Professor of English Law here in Cambridge in the Faculty of Law. David has long since pursued interests in the links between administrative law and public law, and has strong interest in the interplay of law and politics, especially. He's been legal advisor to parliamentary joint select committees on human rights and so on in the past. Martin Jones, as the respondent, is CEO of the Parole Board, and Martin has been Chief Executive Officer of the Parole Board since 2015, previously having worked some 25 years in the criminal justice system in a range of delivery and policy roles, some very important roles too. So David, over to you for a 15-minute brief talk, please. Thank you.
Thank you, Loraine. My topic is the relative importance of transparency, independence, accountability, and public confidence. People generally recognize that each of those notions are capable of providing some legitimacy for people who make decisions that affect people's liberties or who are using public money. I say some because a large part of anyone's legitimacy in a role comes from how well they actually do the job, rather than how well they enable other people to oversee how they're doing the job. Those things also help to maintain public confidence. But the meaning of the terms changes with context. No formula can tell us in all contexts what the appropriate form of accountability and so on is. And we need to take that into account when thinking about how that might apply to parole. Transparency, accountability, and independence are all capable, at least, of being goods, carrying normative weight. None of them, however, is a good in itself. They're all instrumental goods. Their value depends on the extent to which they support good decision-making. I should put a word in parenthesis. Good decision-making itself is a very complex notion, which I'm not going to try to unpack this evening, but it includes fairness, reasonableness, lawfulness, as reflected in common law requirements, as well as alongside other values which can be thought of as more good administration values. Public confidence, by contrast, isn't a good. It has no normative weight of its own. It's a state of affairs that may or may not flow from the quality of decision-making and from reassurance offered by independence of decision-makers, systems of accountability and transparency. Establishing public confidence may be a goal of the systems for accountability and transparency, but I want to suggest that the main goal of such systems, the main goal, should be to optimize the quality of decision-making, not to worry about how people outside view it. In the context of parole, I suggest the first importance is to be allocated to independence. Simple reason for this: in many of the situations with which the Parole Board is dealing, independence is a legal requirement. Independence specifically of the parties and of the executive, because many decisions affecting liberty are unlawful unless the decision maker is independent and impartial. That flows from the Human Rights Act 1998, giving effect to Article 5, Paragraph 4 of the European Convention on Human Rights. And I will read that. Everyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court, and his release ordered if the detention is not lawful. Now, for people who are serving indeterminate or life sentences, once they've served the tariff period set for retributive purposes, the conviction of the original offence can't of itself justify continued detention, and continued detention on grounds other than the original offence must be decided by a court. Now, to be a court, it must be, as I said, independent of the executive and the parties. It must also offer guarantees of judicial procedure, which may vary as appropriate according to the nature of the detention. The guarantees must always include, however, competence to, as Article 5 says, to decide on the lawfulness of detention and order release if the detention is unlawful. Case law has long established that it's not a court if it has merely advisory functions, and a power on the part of government to give directions to the decision maker may present a problem of lack of independence depending on the nature of the direction in question. Independence is a tricky idea. I want to stress that it has to be independent of government in order to ensure that its decisions about liberty and imprisonment meet the requirements of the Human Rights Act and the ECHR. And it also improves the quality of decision making by preventing the exercise of its functions from being dominated by party politics, public pressure, and so on. In reality, of course, a body like the Parole Board can never be fully independent in that sense, so long as their resources, membership, remuneration, estate, budget, and supply of administrative and other support depend on decisions taken by the executive. Curiously, courts have said that the Parole Board can be a court for ECHR purposes without being free of that kind of political control. But I think it's noteworthy that in 1988, a serving judge, Lord Brown Wilkinson, identified government control of ordinary courts, funding and other resources as a significant threat to judicial independence. So what we're being told is there's one approach to be taken for the ordinary courts and another method of evaluation for things that have to be regarded as courts for ECHR purposes, but in some way are regarded as being of lower significance. Protecting independence depends on a number of controls which are hard to achieve given the effective inequality of power between the board and the government, coupled with a perhaps general perception the board, although required to act judicially, isn't actually composed of people who enjoy the respect and status accorded to judges. In fact, the way that this review is being set up seems to me to carry with it a sense that parole is in some sense not a properly judicial decision-making activity, and that outsiders therefore have a legitimate interest in overseeing and even influencing it. And that, I think, is worrying for much the reasons that Simon Crichton mentioned a few minutes ago, that this is about, ultimately, not a balance between rights, but about the rights of the person who is detained being considered in the light of a number of other non-right interests or preferences. Turning to accountability, leaving aside judicial accountability through an application for judicial review, accountability and transparency aren't legal requirements. They're aspects of good administration, although aspects of transparency, such as open justice, are echoed in the common law, or the requirements for open justice, general principle of the common law and our constitution. And some of the possible steps that Faith Geary outlined in her very thoughtful presentation this evening would help to encourage transparency. I'll come back to transparency in a couple of minutes, but first of all, something about accountability. It's a much used but very rarely defined notion. Mark Bovens, a scholar of the subject, has described it as, I quote, a garbage can filled with good intentions, loosely defined concepts, and vague images of good governance, end quotation. And another scholar, John Ure, an Australian scholar, has said that it's, quote, probably one of the most basic yet intractable of political concepts, end quote. And that brings out the extent to which it is indeed a political concept, not a legal or moral concept. I think we can say, nonetheless, that when designing a system of accountability, we need to ask at least 7 pairs of questions. The answers to these questions each require careful thought about the nature of the functions under review, the constitutional position of the body reviewed and the reviewer, and their independence and relationships, the impact of review on the effectiveness and quality of performance of functions. I always get very worried about the danger that while accountability might be thought to be a useful tool, you end up with an industry. There is an accountability industry that comes to treat accountability as if it were an end in itself, regardless of the cost to the thing being reviewed in terms of its efficiency, effectiveness, and timeliness. And we also need to think about the normative assumptions that underlie each of these activities. So the 7 pairs of questions. First, who is to be accountable and why? Second, for what are they to be accountable and why? Third, to whom are they to be accountable and why? Fourth, by reference to what criteria are they to be accountable and why? Fifth, over what time period are they to be accountable and why? I mean, are we going to do it on the basis of annual reports or review of individual events or monthly performance? Because that's completely changes the nature and quality of the exercise. Next, sixth, how are they to be accountable and why? What are the procedures, the mechanisms to be? And seventh, what rewards or sanctions are to flow, if any, from the review of the performance of their tasks and why? You could think of it as consequences. Now, each of those pairs of questions requires careful thought, and I don't have the opportunity now to go into them. But one general comment is, or 2 general comments. First of all, there's a tension between accountability and independence. And the more we think of parole decision-making as a judicial function, the less easy it is to justify extensive forms of external accountability. And the second general comment, people tend to judge bodies mainly, as I think I said earlier, in respect of their reactions to particular decisions. And where moves to increase the level of accountability are stimulated by a decision or decisions that appear to outsiders to be substantively worrying, the procedures for allowing accountability are not of the same logical type as the problems perceived by the public. if you put in place a system of general accountability, looking at how things are done, how effectively they're done, that is not the same as putting in place a system that secures good decision making in individual cases. It may not hinder it, but in effect, accountability is being used as a proxy for quality. Turning to transparency, it can be an aid to accountability and also, of course, to performance management. It involves clarity so that anyone at any time can see what's going on. First of all, it makes it clear who does or is responsible for what. Secondly, it makes clear the criteria that form the basis for decision making. And thirdly, it gathers or allows people to gather performance data so that for whatever purpose, the performance of the body can be assessed. And one consequence of that may be to facilitate accountability. Now, the value of transparency varies from activity to activity because it's a utilitarian rather than a deontological good. In the case of decisions about parole, it's useful to the extent to which it aids rather than hinders good decision-making, directly or indirectly. But there's a tension between transparency and confidentiality. And where you're dealing, as has already been mentioned, with people whose personal records and affairs, medical records and so on, may be powerfully engaged in decision-making, there has to be a limit to how far transparency can go without endangering the rights of those people to confidentiality and respect for their private lives. And those are rights, not just interests, those are rights. And for that reason, transparency seems to me to be less important in the context of parole than both independence and accountability. Public confidence, coming to our last idea, may be generated, as I've said, by accountability, transparency, and so on. But as I've said also, it's heavily affected by public perception of the appropriateness of decisions in particular cases, regardless of any system of accountability or transparency. But public confidence is a slippery notion because it can mean one of a number of things. First of all, it could mean genuinely confidence of a significant part of the public as a whole. Now that's difficult given the fact that, as we heard yesterday from Professor Julian Roberts, there is remarkably little information, reliable information, about how the public views the parole system as a whole, the Parole Board in particular, or particular decisions. And one of the interesting studies that I've seen on public confidence was what in the 1980s, a study of police and people in London. One of the things that disclosed was, from talking to a lot of people, that the confidence that individual members of the public had in the police was inversely proportional to the amount of contact they had had with the police. So the public is not a monolithic notion. It's all sorts of interesting separations and divisions have to be taken into account of. So that's one possibility. Secondly, it could really mean the confidence of ministers, which is a different and political thing. It could mean the confidence of parliamentarians, which is something else again. It could mean the confidence of special interest groups, or the confidence of individuals with a particular interest in a particular case, a victim, let us say, or victims as a group. It could mean those people, or that subgroup of those people, who happen to have the ear of parliamentarians and or of those who run newspapers, other media outlets, or have access to social media. It could mean the confidence of the people and organizations who run news media and social media. Now, to some extent, they merge into each other, partly because, for example, the people who run the media are themselves opinion formers. And loss of confidence among a relatively small number of people could assume great practical importance if those people have ready access to and influence over parliamentarians and ministers. So there seems to be a problem then with public confidence, which seemed largely to be to emerge from unsubstantiated claims that the public is concerned about this or outraged by that. If one allows public confidence to drive policy making and institutional design, it allows politicians to have a powerful weapon for undermining independence on the part of the decision maker. It's accordingly, in my view, a bad thing. I'm not saying public confidence itself is a bad thing, but if it's allowed to become a focus for guiding reform or shaping procedures, then I think it is a bad thing and will lead to bad decisions, at least until such time as one has educated the public and decided very clearly which bit of the public one is interested in. It should therefore, at the moment, in my view, be given no weight in policy making and should not be regarded by parole decision makers as something to be pursued beyond perhaps helping to organize or assist public education campaigns. So my conclusion, for the reasons I've outlined, that I hope make sense, I suggest that the relative importance of our four concepts in the particular context of parole decision making is as follows. Number one, independence. Number two, accountability, subject to the caveats I've mentioned. Thirdly, transparency. And fourthly, public confidence. Thank you very much.
Thank you very much, David, for asking those searching questions about independence, accountability, transparency, and public confidence. We're going to move immediately now to hear from Martin Jones, who's going to respond for a brief 5 minutes. Thank you.
Thank you, Loraine. I'm really grateful to David for his thoughts on that question, which were really enlightening. I think this is a really good question for the parole system and for tonight's event. Transparency, independence, accountability, public confidence, of course, they all matter. But how do you balance those? Are some more important than others? And is there tension between them? To answer the question, I think you need to consider some of the fundamentals, and some of the fundamentals that were picked up earlier, in particular by Simon and Faith's presentation. What is the role of the Parole Board? It's worth reminding ourselves of the primary role. It is to consider whether a prisoner's continued detention remains necessary for the protection of the public. Now, clearly that is a fundamental question, and I completely agree with Simon. This goes right back to the rule of law, the role of the criminal justice system and trust, the lawfulness of someone's detention under the convention. And I sometimes think that we treat parole as the dirty secret of the criminal justice system. Someone will often receive a life sentence or a very long sentence in open court, and then the parole board almost let them out in secret some years later. I'm not sure that's necessarily good for understanding of the system. We shouldn't treat parole as a dirty secret. So more, I think, needs to be done to ensure confidence and trust in the system, and in particular to combat misinformation. And to build on what David has said, I completely agree there's a danger in public confidence. I would see it more as public education and public understanding that we need to tackle. Because most members of the public think, from what I understand and the people that I speak to, that the parole will release everybody that they see. Indeed, probably everybody that's released from prison is released on a direction of the parole board. And indeed, we release most people before they have been properly punished. Most members of the public think that everybody that is released by the parole board reoffends. Of course, that's not the truth. In truth, it's less than 1 in 4 of the people reviewed by the parole board each year is released. And our proven SFO rate is actually 0.5%. So 99.5% of the people released by the parole board in any given year do not commit a serious offence in the period thereafter. Now, that's as low as I think any system in the world. It's as low as can reasonably expected, unless, of course, we can develop a crystal ball for the parole system. Few people understand that the parole board, as well as reviewing the lawfulness of detention, is ensuring that people who are kept in custody lawfully, and that we do not keep people in prison arbitrarily. And that is a hugely important question. I agree that the primary aim of our parole system and the primary aim of this work should be to ensure that our decisions of the highest quality, that they are fair to the prisoner, and crucially, to ensure that they are independent decisions as part of it. We are making decisions, judicial decisions here, and I certainly am one that will back that to the hill. And if sometimes if people don't agree with parole decisions, I'm happy to explain them, but I will not apologise for them. Whilst I am very clear that decisions should not be impacted by anything other than the evidence presented to the panels, I do think it's critical that we are transparent about our decision making. How can we expect victims and the public to have any confidence at all in our decisions if they know nothing about them? And we shouldn't duck that. The board has now issued more than 4,000 summaries of our decisions. Almost all of those decisions have been provided to victims. We are also publishing our reconsideration of decisions so people can look at the lawful basis of our decisions, and occasionally we set aside our decisions as part of that, and I do think it's important that we understand that. I also agree that accountability is important. I'm the accounting officer for the parole board. I'm spending public money. I'm spending £21 million of public money this year. I need to be accountable for the decisions that I make. But what does accountability mean within the context of a judicial decision? It cannot be about blaming people for difficult or controversial decisions if those decisions are properly made. But I do think sometimes it's about standing up for the system and not ducking that. I spend considerable time talking to the public, to victims, to politicians, to select committees, to prisoners' families. We use social media. We talk to journalists. What I found from all of those conversations is that we have nothing to fear. Most victims want to be listened to. They want some reassurance. They want information. They want explanation. They want to be treated with humanity. I sometimes buy a victim a cup of tea when I speak to them, and I listen. But we should not mislead them. We need to give them honesty in relation to how the system works, and the fact that the parole board will be releasing people when they no longer represent a risk to the public. That's the way the system works. That's the way the law works in our country. Most members of the public are actually reassured when they understand how our system works, and the public actually are less punitive than people would think. And I would completely agree with the points made yesterday by Julian. I think public education could do huge things for our system. And unless we answer those difficult questions, how can we expect people to have any trust and any confidence? I don't think that's tenable. We need to embrace that challenge. I do think there's a huge amount more that can be done by way of public information to explain some of the facts of the system. Can we include more information in our summaries that we provide to victims and the media? Can we make them less full of jargon? I think that's a challenge that we need to look at in the next few years. Should we allow more journalists some regularised access to our hearings so they can report on the decisions that we made? We've allowed a number of journalists into parole hearings in recent years. All of them have been mightily impressed by the parole system. Earlier this year, we had the Victims Commissioner came and observed 2 parole hearings. She was thoroughly impressed by the process. Why do we hide from that, provided that we think carefully about that system? I think if we embrace these things, we would have a stronger system. I look forward to the further discussion. Thank you.
Thank you very much, Martin. Thank you to both of you. In the interests of time, I'm just going to pick out a couple of questions at this point so that we have longer later, essentially, for a more open Q&A to the whole panel. The questions I've picked out both, I think, reflect some of the points that we've just heard about accountability and transparency and so on, as well as being related to public confidence. So the first question is from Bradley Reed. If the initial offence in effect no longer provides adequate cause for continued detention once the related tariff has expired, should debate and scrutiny of the offence be excluded from hearings that are past tariff?
Shall I have a go at that?
David, briefly, please.
Briefly. The answer, I think, is that they can properly take account of the details of the offence, but not for the same reason as a court takes them into account at the sentencing stage. They're relevant to the extent that they're relevant to danger, the future danger, not to past offence commission. So one needs to bear in mind the background in order to think about the future, but that's, I think, the limit of it.
Okay, thank you. Martin, would you like to add anything?
Yeah, I would. So, of course, as a court, we need to take account of all of the information that is provided to us, and the starting point for most parole cases is, why is that person in prison? But I do totally agree that the more time has passed since the commission of the original offence, the less relevant it becomes. And it particularly becomes true of the people serving an IPP sentence who are way, way, way beyond tariff. And quite often the question is not the original index offence, you know, a street robbery committed when somebody's 18 or 19, but the risks today of people that perhaps have been broken by custody. And that is quite often the heart of the parole decision being taken in 2020, rather than the offence that was committed 15 years ago.
Okay, thank you. The second question that I've identified actually relates to the involvement of other agencies. So it's from a question from Andrew Sperling, who says, Faith mentioned that members can and should be able to use powers to ensure progress within reviews for difficult cases. Can the board fulfill this role in cases which require funding and coordination between lots of different agencies, such as local authorities and clinical commissioning groups, and in which the board has no power to compel those agencies to do anything at all? So David, I thought this has resonance for your questions about accountability. Who is accountability? What is the extent of accountability?
I suppose that is so. I have no experience at all of how the different bodies work together. So I'll leave that to Martin. But I think it is true to say that if you're thinking about ensuring accountability for a process, it's very important to make sure, first of all, that the people who make the decisions are able to enforce the decisions if they're going to be held responsible for those decisions. And to that extent, it would justify more coercive power in the board than there is at the moment.
Okay, thank you. Martin.
I think it's a really good question, Andrew. Thank you for that. We've spoken about this before. I think there is some power around actually the board having power to enforce its directions and make things happen. And in particular, what I quite often see is the board trying to remind people of what their statutory responsibilities are. It's not that we're asking them to do anything outside that. Local authorities have responsibilities under the Care Act. It's just about ensuring that happens. The only thing I would caution against, I think, and I know Simon, I can see in the background of the picture here, is that the board doesn't then end up taking 2.5 to 3 years to bring a case to a conclusion. I think we need to make decisions with incision, rather than allowing ourselves to sort of get distracted from our central task to decide whether somebody is safe to be released. And once we've reached that conclusion, it should then be about requiring the authorities to put the appropriate arrangements in place, for an elderly man that needs a care home to go to. Why should that take longer than a few weeks? I see those cases drifting for months and months and months, and I think with greater powers we can make things happen much more quickly, and that's what I'd like us to see to do. But it should be weeks, not years.
Okay, thank you very much indeed to both of you. Again, in the interests of time, I'm going to move us on to the third presentation, this time from Professor Rob Canton, who's Professor in Community and Criminal Justice at De Montfort University, based in Leicester. His interests include community penalties, probation, prisons, punishment, sentencing, human rights, and he is a key academic contributor in these areas. And the respondent in this case is Professor Nick Hardwick, who has had a part-time role at Royal Holloway University after a career leading organisations in the voluntary sector and in the UK criminal justice system, including a period as Her Majesty's Chief Inspector of Prisons for England and Wales, and of course, and widely known, chair of the Parole Board between 2016 and 2018. So Rob, over to you in the first instance.
Thank you very much, Loraine, and thanks to everyone for the opportunity to participate in these seminars, and particular thanks to Nikki Padfield. I'm going to try and share my screen. Faith showed me how it can be done. I wonder if I'll be able to match it. Here I go. That looks promising, doesn't it? How much I owe to... That's better. How much I owe to the presentations yesterday evening and this evening, all of whom I've enjoyed so much, that this will be apparent as I go along. I'm not going to say a great deal about the board because so much of it has been already much more eloquently said by others who are better informed than I am. It does seem to me, though, that as Nikki Padfield said last night, it seems to me as a matter of justice that once someone has served the sentence awarded by the court, the presumption should shift. So authorities should have to show why someone ought not to be released when they've served that tariff term. And the difficulties of how to demonstrate reduced risk, especially when they're in prison. So people have said that they should strive to do that, and one can agree with that, but quite how you do that. And I think there's a risk, as Joe Grady and Fergus McNeil warned us last night, that there's perhaps too much emphasis placed on participation in programs, probably because as the best proxy measure we've got for whether or not rehabilitation has been accomplished. But as Simon cautioned us, this is not an exact science, and participation in programs, successful completion of programs, is not necessarily a reliable indication of anything very much. Say a few things about victims. This is a subject I find really quite hard to talk about because victims are often the focus of discussion. They've already been mentioned on a number of occasions this evening. But as it seems to me, if the primary focus of the board is to look at risk, victims are not often in a position to comment on that. Now, of course, sometimes they are. There are cases of domestic violence or perhaps of stalking, or where there's been continuing animosity between the offender and the victim, when of course they are in a position to comment. But they are often not those most at risk personally. But the more they are involved and brought in, the more you get that push towards resentencing. And the circumstances of the original offence will be revisited, not, as David said, from a different point of view, but from the exact same point of view, and victims will feel dissatisfied. Because despite the best efforts of Angela Cousins, as she spoke last night, to help victims to understand their role, in reality, their boundaries of that role can be really quite difficult, both for them and for others, to hold in the face of obvious anxieties and distress. And they may come to think that their involvement is tokenistic, that they're being condescended to, or even further victimized by feeling that they're not being heard. So these are risks. I think the more that you push victims to the forefront in this, the more vulnerable they are to these kinds of problem. What about offenders themselves? Perhaps we haven't said so much about that and where they stand in some of this. Now, my suspicion, and I think there's evidence of this, that some people will feel a sense of injustice. They've served the term. We know that people do feel this. They've served the term. Why are they still in prison? And personally, I could well understand that it's little short of outrageous that they're told that their release depends upon the fulfillment of programs which, oh, by the way, aren't available to them. And this uncertainty about the criteria for release, about how exactly they're supposed to go about demonstrating that their risk has been reduced, adds to what Ben Crew has aptly called the tightness of imprisonment, feelings of tension and anxiety that are generated by this uncertainty. And it wouldn't be surprising if this did lead to a certain amount of cynicism about the process. It also runs the risk of, Joe Grady said last night, that people might attend programs for the wrong reasons and in the wrong spirit. Instead of seeing what they can get from the programs and learn from that, they will see it as just another thing that they have to do and get through, spoiling the experience for themselves and perhaps for other program participants. And in circumstances like this too, offenders may come to be very wary of their supervisors and may be reluctant to disclose problems, so that if they end up being recalled, they'll be frustrated, they'll be disaffected, they'll be confused by the recall. And all of this puts people in entirely the wrong kind of relationship with their supervisors, who are perhaps, we hope, subsequently going to be required to support them in release. Why would they trust the probation service if they don't feel that they've been fairly dealt with? What about the public? And I understand and accept very much what David has said about public confidence. We know, and Nikki reminded us yesterday, that parole is not an early release system, but it used to be. And I suspect that in the minds of many people, it still is. And even if it isn't, as Simon eloquently put it, you're never going to win popularity by releasing people who often are thought simply don't belong among us. And very often the public only gets to hear of notorious cases when they come before the board, and that revives memories of dreadful crimes, and they only hear of them, and then another time they hear is when serious offences have taken place on licence. And then the public feels a compassionate solidarity with victims. Why wouldn't they? And that feeling of all of that, I think, conduces towards a suspicion of a resistance to the very concept of parole, no matter how diligently the parole board goes about its work. Then the community supervisors, the probation service. Now, one thing that one often hears from government is that when people are released from prison and they are subject to license, they are continuing their sentence of imprisonment, only now in the community. I've never understood that principle. What does it even mean? They are subject to restrictions and limitations, but is it being said that now we're going to make the experience onerous and oppressive and pointless? What does it mean, adding to that, over and above the principle of risk management? And maybe it's in tension with risk management as well, rather than supportive of it. The more demands that you make of people, the more assiduously you supervise people, the greater the scope comes about for non-compliance. Does non-compliance mean increased risk? Excuse me, by no means necessarily, I think. We also need to understand why and how people do comply and why they fail to. My final point on this slide, I'll skip the one bit above it, but we need to guard against the possibility that we'll get into the position that some American states have encountered, where community supervision on parole becomes experienced as the tripwire, or to use another metaphor, the minefield. And in a recent American study by Bruce Weston, people on supervision had a much lower self-reported crime rate than those who were unsupervised, but they were reincarcerated twice as often. to a point where the study found that being supervised was one of the strongest predictors of a return to custody. It was second only to relapse into substance misuse as an occasion for return. And it's at this point, if I can use yet another metaphor, which I pinched from Fergus McNeill, there's a risk that probation becomes not the fuel in the tank, but the hole in the boat. Now, a lot has been said this evening about the need to enhance public understanding, to educate the public, and who could disagree with that? But we need here, when we embark on that, to consider the salience of the emotional in criminal justice, which is something that Ian Loader has spoken about really well. If the whole criminal justice process is suffused with emotion, whether we like this or not, whatever we think of that, it is. And if people do have these strong and powerful and passionate feelings, and often, of course, they will, how are we actually going to encounter that? Well, Ian Loader suggests there are three ways in which you can try to do this. You can try and adduce evidence and reason and argument. And that's something that all of us, I think, would favor. One might be our first instincts, but it has a very limited potential. It doesn't have no potential, but I think there's a limit to how far you're going to be able to persuade people about this. Now, there's another model, which Loader refers to as the insulation model. And that used to be the practices of the Parole Board in the old days. Leave it to us. We're the wise heads. Everything will take place in secret. You don't need to bother about it. Trust us. That's no longer, we no longer live in days where that's even possible, even if we thought it was a good idea. So Loader's challenge is to find ways of redirecting our emotions. We need to acknowledge the effect they have on us and the effect they have on the public, and expose them to public scrutiny and debate. And for Ian Loader, who has said has a wider consideration than parole, he thought that participation in things like community panels and all sorts of things like that were of value. I think for parole, one of the things you might attempt to do, and I don't now mean that you tell stories and disclose intimate personal details that would name and identify people, but when Faith gives an example of a little boy who comes home from school to discover his mother has moved, that's not untypical. And I know Faith wasn't suggesting that it was. That's the reality. Many offenders have this utterly miserable, scarred, traumatized background, and we never encounter them in, the public never encounters them in that, because they are reduced to the worst things that they have ever done. And people are always more than the worst things they've ever done, and they are never merely carriers of risk factors. And I think that there is scope for personalization and trying to tell stories and to explain to people that some of the backgrounds and biographies is a way of engaging other kinds of emotion, not emotions of aversion, but emotions of a more positive salience, emotions of compassion, not just for victims, but also for offenders. And indeed, remembering that the abused child of today and the offender of tomorrow are very often exactly the same person, as Jean Corsten reminded us so eloquently in her report years ago. We speak about public confidence, and it's right to keep that in its place, but sometimes I wonder if we're talking about confidence or legitimacy, and this isn't something I haven't worked out to my own satisfaction, so I'll try and blag it and be interested in any thoughts that we have. So Julian Roberts last night spoke about the difference between public knowledge and public attitudes, and they're related, but they are distinct. And when Caroline Corby last night introduced the idea of myth busting, that addresses knowledge, and it merits even more attempts. And Martin has recently spoken about the ways in which you can tell people things and enlighten them and explain things to them and adduce arguments about really, really impressive reconviction rates and low serious further offences. All of that is really good stuff. But we need to, I think, bear in mind that some attempts in the past to enhance legitimacy have had the limited effect, and maybe sometimes even the opposite effect. We shouldn't assume that the more knowledge we give, the more people are going to like it. we need to think about the difference between being safe and feeling safe, which again is about emotion. But what if it turned out, if the principal emotion here wasn't fear, but something closer to rather, say, disgust? And it does seem to me that very often this is the subtext that's around. It's not an easy thing to talk about, but when the newspapers tell us about horrible cases and people talk fear, sometimes seems to me that it's fear that is masquerading. And really what's happening is something much closer to a sentiment like disgust. These are people who are not fit to live among us. And if that's the case, any number of reassurance about reduced risks might miss the point. Solutions. Well, I've pitched an idea here from Fergus McNeill, Margaret Schinkel and Hannah Graham, who in some advice recently to about the Scottish parole system suggested that we should try to establish reintegration as part of the formal remit of the board. The advantage of doing this is to remind us that of the duties owed to people leaving prison, especially when so many of their problems are aggravated by prison itself. We can't insist that people have to change and then refuse to accept that they're attempting to do that, or obstruct them and put blocks upon that. I've spoken about shifting the presumption of proof, and my final point is that we should learn from past attempts. Criminal justice policy often shoots itself in the foot, and it's often confounded because it's by its failures to understand the influence of the emotional and thereby to miss the point. Thanks very much for listening to me.
Thank you very much, Rob. And we'll move swiftly on to Nick Hardwick, who is going to respond.
Thank you, Loraine, and thank you to Rob for a very thought-provoking presentation. So I'm really glad to be here. I think it was Simon who talked about the War Boys case being the elephant in the room, and it certainly was a driver for some of the changes we've been talking about over the last 2 days. And I think Martin and Faith would agree that while that was happening around us, we tried to very consciously shape the agenda that came out of the War Boys case. So as people know, in my case, that wasn't terribly successful. But in the broader policy terms, I think some of what's come subsequently is exactly what we were arguing for. So I'm personally, pleased that hearings are going to be opened up to some extent, and I'm pleased that there is now a discussion about greater independence for the board. I think those two things go hand in hand. I absolutely would be concerned about greater openness in the board if that wasn't matched by making real the board's court-like court status. But if you were able to do that, then it seems to me the argument should be, I would go further perhaps than some other people in this call. I mean, my view would be that the technology that the Parole Board's developed enables us to say cases should be held in public, all of them, unless there's some, there has to be a reason why it shouldn't be in public rather than a reason why it should be. That would be my take on it. But I don't want to spend time talking about that. I want to come back to an issue that Rob talked about in his talk and others have touched on as well, which is the issue of kind of risk and the role that plays in Parole Board decision making. And it seems to be one of the things about a root and branch review is that some of our answers to that have in a sense been giving a better answer to the same question. Well, maybe there's a problem with the question that we're being asked. Maybe actually a system that's entirely based on risk is problematic in itself. That again, Rob and Simon and others have hinted at. I mean, it struck me yesterday, listening to Joe, thinking it'd be interesting to see now those, where she talked about the difficulty of running programs during the period of the epidemic. Well, it seems to be one of the questions we're interested to ask about that is what difference has that made? Have those people who haven't had these carefully tailored interventions, are they more likely to offend than people who have had them? That would be something that'd be interesting to find out, I think. And I, for one, am worried by the sort of medicalization of some of the terminology we use around this, the treatment of this, because I think it almost infantilizes prisoners. Both when I was at the Parole Board and subsequently when prisoners knew I'd been chair of the Parole Board, and I'd go to a prison and they'd ask me, what do I need to do to improve my chances at a Parole Board? Should I wear a suit? What do I need to do? And it was a difficult question to answer, because the truth was it wasn't really about what they did. It was about what the system did to them, because the system was going to prod them a bit, and then it was going to see how they reacted and make a decision on that basis. And actually their day-to-day behavior outside that wasn't, on the whole, terribly relevant. And I think that's problematic. I was talking to some students the other day about the 1950s novella Minority Report that subsequently became a film. And some of you remember what happens in that film is it's set in 2050, and then there's a police department in the United States whose job it is to apprehend people for the crimes they are going to commit in future. And it's a dystopian science fiction novel. But what are we doing with some of the people now, certainly who are suffering indeterminate sentences or the extended determinate sentences? We're holding them there for the crimes they might commit in future. In some cases, very specific crimes we're holding them there for. Right? So explain the ethical difference to me between those prisoners we're holding for what they might do in future, given the poor results sometimes of the means we have to test that, and that dystopian American police department. It may be, it seems to me, that if you have someone who's had a life sentence, there's a justification for that we'll use these tools to decide whether we're going to let you out early, subject to what with the provisos that Rob made. But it seems to me that for IPPs and for extended determinate prisoners, what we're actually saying is, how late are we going to let you out? We are minded to let you out late, unless you can convince us otherwise. And that seems to me to raise some pretty profound questions, where if you took some of what Faye was saying to, an extreme, where you have AI scanning the documents and then putting the results into a computer with an algorithm programmed in that comes out with the answer about whether someone should be released or not, which I think is pretty close to the system they now use in Wisconsin. So it is not quite as extreme as all of that. So in my view, I think what Rob prompted us to say, and what other speakers have prompted us to say, is that maybe we need to not just improve our answer to the existing question, but maybe we need to challenge the question itself. And so surely if you're talking about a root and branch review, maybe we need to think about whether this idea that we can continually extend the remit of the Parole Board, so they're using their risk assessment tools to make those decisions on more and more prisoners on a wider and wider range of cases, whether that's something that we should challenge, and whether a increasing focus on what critics might call, and I exaggerate to make the point, actually a very medicalized approach to risk, is something that is a safe basis on which to determine people's liberty and assess whether we are going to keep them in prison for their future crimes. Thank you.
Okay, thank you very much indeed, Nick. A very important response, I think. Again, in the interest of time, I'm just going to pick out one, possibly two questions at this point, but anxious that we get to the panel to ask more questions, but also anxious to allow Dr. Harry Annison time to provide some concluding comments. So the first question that I wanted to ask, this is from Sean Jones. What are your thoughts on the risk that forcing the offender management team to produce only one recommendation compromises their individual professionalism and value. As a prison-based probation officer, I have significant concern that this move will be de-skilling and remove some of the key elements of my job that I have trained and gained years of experience to do. Is there not a risk that the person with the loudest voice is going to be the person heard in terms of determining the recommendation? So over to Rob and Nick to comment.
Are you going to start, Rob?
I'd be happy for somebody else to answer this. We heard about this last night, didn't we? I think Angela Cousins actually welcomed that, and I can understand that a parole panel might be quite bewildered if they were being given contradictory advice by professionals proceeding and from the same with the same information and the same professional standings. But I accept Shan's point here that personally, I think a bit of tension is valuable. I think it's okay to expose panels to those legitimate differences of opinion if they're well argued, and I don't think they ought to feel under undue pressure to come up with a single answer, because a prison-based probation officer will have different considerations and from the one that will be from the outside supervisor.
I think I just wonder whether we have understood that correctly. I think that would be, I don't think that can be the case. I think experts who are giving evidence to the parole board need to give their best possible evidence based on their assessment of the facts. And if they disagree, they disagree. I think there may have been some misunderstanding here. I would be very, so I think we could put Sean's mind at rest. I think we will still want your honest opinion on the facts, and that would be the right thing for you to do. I would be amazed if it were different.
Okay, thank you. So if we can move to a very brief panel discussion. There is a question from Andrew Sperling, who says, Nick's question about the absence, whether the absence of treatment and interventions during the pandemic has made any difference, is interesting. Isn't the problem that there is no effective way of measuring this, and also that many members rely on programmes as providing the evidence they need to make an assessment? So Nick, would you like to start?
Well, I think I would have thought it would be possible to. I think one of the interesting things about the pandemic, dreadful though it's been, is it does enable us to test a number of different theories. So why don't we look at what happened to the people who've been released who haven't done the programs who otherwise might have done, and the people who've been released having done the programs? I would have thought we could identify them. We could look at their 1-year offending rates and see what the difference is. And I would be interested to see. And I think that, and I think there's a problem if, and I don't believe they do it much, but parole board members are not simply assessing whether somebody has done a program or not. That shouldn't be what they do. Not done a program, tick, not done it, cross. It's about whether, under the current system, whether their risk has reduced. So what has changed as a result of them doing that program is what they should be considering, not whether they've done the program. And I think there's one of the things, I'm sure parole board members would agree, there's a kind of, because of the lack of protection some of them get, I feel, and the lack of independence of parole board, there's a kind of need to justify your decision sometimes with something measurable. So there's a temptation to slip into, well, they've done these programs that were asked of them, that would be enough. But I don't think that that's the test. It's whether the behaviour and the risk has changed as things stand at the moment.
Okay, thank you. Let me slip in another question. This may be a question for Faith. It's a question from Thomas Guinea. Faith talked briefly about the need for a radical rethink of the recall system, Could you say a little more about this with particular reference to A, how happy the parole board is with the current recall process, and B, whether it makes sense for prisoners that are originally released automatically to then be subject to parole board discretion if they are recalled?
Thanks, Loraine. Yeah, so in terms of how the current recall system works at the moment, it's been a growing proportion of our work, and increasingly it's a growing proportion of the number of cases that are going to oral hearing. And as I said, oral hearings have huge value, particularly where that's needed to be fair for the prisoner. But I think there's a strong argument that in a lot of recall cases, those decisions could be made a lot earlier. And particularly some of the issues we see is with the information coming through to allow our panels to be able to make those decisions either on the papers, so or kind of through a telephone hearing. So that's one, again, as Nick said, COVID has given us a chance to try things. And one of the things that we have seen in COVID by reviewing some of these cases again is actually there's a more proportionate way to deal with them. But I think that requires the system to almost make sure that that information is coming to the board quickly. And sometimes what we see is delays in getting that information that panels need to really be able to consider at an early stage whether it needs an oral hearing or they can make a decision on the papers. And that's why I think it needs a look across the system at kind of how that works. And whether there's a way that we can get much earlier access for professionals. So some of the biggest challenges are probation officers being able to get access to talk to a recalled prisoner and then be able to use that information to inform their report. When we've got that, our panels can make better and more informed decisions. But I think there's probably a way we could do that quicker than we do it at the moment.
Okay, thank you. There are many excellent questions, but I think this will have to be the last question to the panel, I'm afraid. And I've just, yes, does anyone on the panel, this is from an anonymous attendee, does anyone on the panel have a view on how the increasingly commercialized environment of risk assessment tools and interventions has an impact on the quality of evidence presented at parole board panels? So I think it's whoever would like to respond to that question. Martin.
Thank you, Loraine. I mean, I think it's hugely important that a parole panel looks at all of the evidence that's presented to it. I completely agree with Nick's point in relation to an undue focus on programmes. Now, the Parole Board last year published detailed guidance in relation to all the different factors that parole panels should take into account when they're making the decision as to whether somebody's continued detention remains necessary for the protection of the public. One of the things that I think is true, and it came up yesterday actually, is simply long-term imprisonment of a long time, unsurprisingly, reduces the risk over that period. And I think there's really good empirical evidence that maturity is a huge difference. So, and then the final point I would make is this point around the single recommendation. I've got to say, I think that's a complete red herring. And the reason I think that's a red herring is the parole board want evidence, and they'll be asking probation officers, psychologists, offender supervisors, and others, what's your view on the risk that this individual presents as a professional? So recommending release or not is a by the by for me. My question would be, what's your view on whether that risk has reduced? What's his behaviour been like in custody? How would you manage that risk in the community? I don't think panels are likely to be overly influenced by the fact that there is a single recommendation. And indeed, the panel members will be asking people directly, what's your view on this? And I don't think that culture will change. And indeed, as a court, you'd expect us to be asking those questions. That's why you've got a court there doing this, and we're not simply going to follow what the administration says.
Okay, thank you. I'm really sorry that we're not able to get to more of the questions, but we'll save them, and panel members may wish to correspond if that's at all possible. We should turn now to Dr. Harry Annison, who's going to offer some brief concluding thoughts. Harry is Associate Professor in Criminal Law and Criminology at Southampton Law School, and co-director of the Centre for Law, Policy and Society. He has sustained interest in practical and theoretical issues relating to dangerous offenders and indeterminate sentencing. So Harry, over to you.
Thanks, Loraine. Hopefully you can all hear me fine. So what I'll propose to do in my time is just sort of summarise, but I'll recognise this is my interpretation and my pulling out of certain themes that I think have come out from the various contributions. So hopefully that plays a helpful role, and I think I'll try and suggest that leads us to certainly one way of looking at this issue overall. So I'll try and get us there in the short time I have. So initially, just to work through in the order of the contributions today. So one thing I took actually from Faith's contribution, which I'm not sure if she actually explicitly mentioned, but inherent in what she was talking about, was actually the Parole Board is of course dealing with a range of different types of cases, if you like, or different types of offenders: determinate sentence prisoners, extended sentence prisoners, indeterminate, in the sense of IPP prisoners, life sentence prisoners, those sentenced for terrorist offences potentially. So there's quite a range there, and in a sense that could be seen as being unproblematic, or it's a question of practice really. How can you deal with those effectively? Can you assess those effectively? But I'd suggest that might tie into our discussions about the challenges around public perception, for example, the expectations, either the political expectations or the public expectations of parole that we might have. You know, those might differ across those various groups. I think one theme, and Faith mentioned this, I think this was a theme amongst many of the contributions, was the importance of what we could call procedural legitimacy, or procedural justice and legitimacy for prisoners. We can come on to other groups, but certainly for prisoners themselves. And one way in which this might be sometimes undermined is recall, as we've mentioned a couple of times. And I think certainly I'd commend the Prison Reform Trust's very recent report on the recall of IPP prisoners, which partly does, I think, the best explanation I've read of actually how recall works, which I admit to really struggling with myself whenever I've tried to ask people to explain it. But I think that points to real concerns about that system and the fact that it's not easy to understand, and I think there are good suggestions that there are problems there and ways to improve that. I've worked on the IPP sentence and sort of argued about that for many years. So yes, I very much agree with what Faith was saying about the potential to do more there. And I know many, if not all of those who have mentioned it would say broadly the same thing. To move to Simon, I think one important point that he made and was echoed later on as well was the need to keep in firm sight prisoners' rights. And I'll come back to this question of what parole or the Parole Board is for in a minute in conclusion. But I think also his point that the Parole Board can be seen as a repository for failings elsewhere in the system is really important, and certainly in my own thinkings about War Boys, for example, certainly it seems like the most plausible way to understand the reaction to that is largely that was a reaction to the failings of other parts of the criminal justice system, as well as, for example, Rob Canton's point about, is this, especially in that sort of case, about public disgust about either the offender or the offences or sort of the way that the criminal justice system is perceived as having dealt with that person or indeed the victims. I know that Simon Crichton urged the Parole Board not to be defensive, and I think that was maybe an ongoing tension addressed in different ways throughout the contributions, was the need for it to, and this actually probably follows on quite well into what David Feldman was saying, is the importance of the Parole Board being independent, of maybe going further in that regard, really embracing its role as an independent court, and indeed to the extent that the Ministry of Justice or others need to allow that, enable that, facilitate that going forwards, then that may well be the case. So a tension there between that confidence, but then public engagement and the accountability issues that might go with that. And I think it's probably not possible to do justice to David's really detailed consideration of all those issues in summary, except to note, as I've just pointed to there, really, that I think those questions about independence and how they might interact with accountability and in turn interact with public confidence and in turn go back round to that central question, as David was putting it, of, well, actually, we want high quality decisions to be made by the parole board, and we need to focus on that, I think was a point well made, and something we could, keep very much front of our minds throughout this this discussion and through the review process. There was, to move to what Martin was saying, this idea again of parole, or slightly, so we talked about parole board being essentially bearing the brunt for failings of other parts of the criminal justice system. Sort of almost paradoxically, at the same time, I think I completely agree with Martin's view that parole ends up being a bit of a dirty secret. So it seems to sort of to achieve a certain type of double whammy there, which is in a sense quite impressive and quite challenging for it. And I think if I interpret Martin right, he was in recognizing that need for confidence and embracing that, and saying there's a way of seeking to achieve public confidence by bringing people in, examples of journalists, the Victims Commissioner, and so on, while maintaining that focus on quality decisions. There was a comment about addressing jargon and reducing jargon. I mean, I wonder whether that's another example of where the parole board is impacted and constrained by the broader system and the challenges it faces there. And it's important to emphasise Martin's comments about the parole board benefiting from further powers, but equally the need to ensure that doesn't lead to endless delays, or the need at the same time to keep in view that importance. Just to put, there's certainly a lot more I could pull out, but being mindful of time in particular, I'd suggest there's value in noting what Rob Canton was saying partly in terms of supervision. So to link back to the parole and the danger that supervision actually acts as a tripwire, if you like. And we've mentioned the need for procedural justice for prisoners, and indeed for others, including victims, before. And I think those considerations about the emotions underlying debates around criminal justice are very important and very well made points by Rob there. Well, and that leads us to the conclusion, really, and Nick observed, well, potentially the wrong question on the wrong premises, if I can summarise that, appropriately. A question about are those underlying the root and branch review, are there dangers there? And equally, as Nick put very forcefully, or rightly, sort of challenged us in terms of saying, are we there? Have we actually arrived at a situation that looks very much like Minority Report or that type of situation? And I think those are considerable challenges that we should put in mind. Just very briefly, my final point in conclusion would be to suggest that we could think about this. One way to think about this is in terms of Nikki Padfield's argument that she's made in a public law journal recently, although I know she also talked about this yesterday, about that you can see the parole board in perhaps three primary ways. That its focus is public safety, and we've heard some people, including Faith and Martin, argue that's the primary role of the parole board. So in other words, we might see that's being underpinned by risk and public protection. We can see it as prioritising ensuring human rights and human rights compliance and supporting the human rights of prisoners. Or we can see it as achieving successful resettlement. Now, I'm not trying to suggest that those are all mutually exclusive and that those are entirely separate. And I think the discussion today, and of course the practice of the parole board, shows that those considerations are always going on. But I think it's certainly fair to say that there are very much tensions there. I mean, one point we could note there is I think those tensions could lead to, and that complexity might be part of the cause for what we could see as perhaps being at times unjustified political or media attacks on the parole board and the parole system, that it's essentially trying to achieve different ends or prioritise different elements of that at different times. And I think there certainly would be a challenge about whether they could fully align. I note that Rob Canton suggested, well, could resettlement be an explicit goal? I mean, in a sense, certainly for myself, I'd ethically support that in the sense of I think it's very important to look towards resettlement, look towards assistance and supporting that. I think that would be a very interesting question to explore in much greater detail about whether you can actually align or revise the goals and the role of the parole board in that way, in a way that actually works, is operative, essentially. So in other words, to misuse Raymond Carver's title of his famous book, what we talk about when we talk about parole, I'm not sure we're all talking about exactly the same thing at the same time. I don't think that's because we don't know. I think that's because of the complexity and the importance of this area. So I think these kind of discussions are incredibly valuable, and I think are starting, really helping to shed light on these kind of issues. And actually, to conclude in a slightly different place, I think the place to conclude will be recognising, as many have said, that actually we need to consider this in terms of the system overall. And actually concluding on that point, I think is the most important point, that we don't want to narrow our focus unduly onto parole and the parole board, when actually so much of what we're talking about engages most, if not all, of the criminal justice system.
Thank you so much, Harry, for a an excellent summary of issues, very succinct too. I'm sure all of us, from not only this evening's webinar, but yesterday evening's webinar too, we're taking away valuable insights and questions, further questions to chew over. So it just remains for me to thank Parole Board colleagues who've helped with the organisation of the webinars, Nikki Peters in particular, but also colleagues in the law faculty. Nikki Padfield obviously has taken an intellectual lead in the 2 evenings, but thanks also to Daniel Bates for his work on the IT side of things, and huge thanks to all the speakers and respondents, and of course to all of you as participants, and for the excellent questions as well. This evening's webinar, as with yesterday's webinar, will be placed on the law faculty website if you want to view the webinars again. So thank you very much indeed to everyone. Good night.